rise.
For the reasons contained in the judgment prepared by Lord Clerk, the Board will humbly advise Her Majesty that the appeal should be, in substance, be dismissed.
Appeal for the judgment, the Attorney General of Trinidad and Tobago versus Palmer.
For the reasons contained in a judgment prepared by Lord Walker, the Board will allow the appeal and reinstate the order of Mr. Justice Musai. The parties have 14 days in which to submit written submissions as to costs.
Appeal for the judgment, Herman Ramdas versus Madeline Balfour Cannon.
For the reasons contained in the judgment prepared by Lord Walker, the Board will dismiss the appeal except to the extent of directing that the payment of mean profits at the rate ordered by the judge shall run only from the 23rd of February 2002. The parties have 21 days in which to make written submissions as to costs.
Appeal for judgment, Nadine Rodriguez and Mother versus the Minister of Housing of the Government and Finance.
In this case, the Housing Allocation Committee in Gibraltar refused to grant a joint tenancy to the appellant and her long-term same-sex partner. The committee's policy was to grant joint tenancies only to couples who were married or had a child in common. There were two main questions. First, whether this was discrimination contrary to the Constitution, and secondly, if so, whether it could be justified. The Court of Appeal in Gibraltar concluded that the policy was not discriminatory. The Judicial Committee of the Privy Council unanimously allows the appeal and declares that the appellant has been treated in a discriminatory manner in contravention of her rights under sections 7 and 14 of the Gibraltar Constitution. On the first question, the Board decided that the committee's policy discriminated indirectly against the appellant on the ground of her sexual orientation. The impact on the appellant was more severe when compared with other unmarried couples, given that the appellant and her partner cannot marry and cannot have children in common. This means that she will never be able to satisfy the policy, which is a form of indirect discrimination coming as close as it can to direct discrimination. On the second question, the Board did not accept that the difference in treatment could be justified in order to protect marriage and children. These can be legitimate aims, but in this case there was no rational connection between them and the discriminatory effect of the policy. Denying benefits to people who cannot marry does not protect those who can. The Board does not seek to dictate what the committee's policy should be. It should not, however, exclude same-sex partners who are in a stable, long-term, committed and interdependent relationship from the protection afforded by a joint tenancy.
Appeal for judgment, Josie Johnson and another versus the Attorney General of Trinidad and Tobago.
For the reasons contained in a judgment prepared by Lord Roger, the Board will humbly advise Her Majesty that the appeal be dismissed, and the parties will have 21 days in which to make written submissions as to costs.
Appeal for hearing, Philmore Jarvis versus Shoppers Pharmacy Limited.
Yes, Mr. Guthrie. Good morning.
My Lady, in this appeal, I appear with my learned friend, Mr. Richard Samuel, for the appellant. The respondent is not represented and is not here, and has in fact not played any part in the appeal. My Lady, I'm aware that the supporting documents are not very substantial, and I wonder if I should make the usual assumption that your ladyship and my lords have had an opportunity of at least looking at them.
My bundle has a page or two of the Court of Appeal judgment missing.
Well, my lord, can I deal with that straight away? I'm afraid there are 3 or 4 preliminary matters. In my bundles, one page of the Court of Appeal judgment has come adrift from its moorings and appears at the beginning of the authorities bundle.
Well.
Not in mine.
If not, then
Which is the missing page in your
it's
bundle?
pages
Mr.
19 and 20 of the record, pages 12 and 13 of the judgment. I think I can say that if those are the missing pages, they are not very
No, sorry.
conclusive. You have got them, my lord.
But 19 and 20 of the record that I have is the notes of the hearing.
Yes.
Is that what my lord, Lord Collins, has
No,
missing?
I must just now tell you which page I have.
The Court of Appeal's judgment in my bundle starts at page 85.
It does in mine too. I think I've probably made matters
Yes.
worse by thinking that my lord must be referring to what was wrong with my bundles, but I'm afraid there
Page
seems to be an
that is missing
independent.
is page 8 of the judgment, which, which would
perhaps
be
we
90, should have been 92 of the record.
Well, I'll ask Mr.
I
Samuel
have the
to.
benefit of having the only complete version of the Court of Appeal's judgment.
Well, I'll arrange Mr. Samuel to supply. Mr. Lloyds has got a copy which can be handed out. My lords, the second matter which I ought to draw to your attention is that included within the record at the beginning at pages 1 to 5 is something which is called the introduction to case.
Yes.
That, in fact, is there as a result of the fact that the record was prepared in Antigua, indeed, I think, principally by the appellant himself. And what he has done is provide an introduction after the event. So it's not a contemporaneous document in any way. And in fact, it sets out a little of the history and indeed incorporates, I think, either part of the advice he received or indeed part of the petition which was put before the board. But that's what that is. Unfortunately, also, the case, and this is my fault, refers on 2 occasions to the Court of Appeal judgment as being a majority judgment, which it was not.
No.
And finally, I hope, can I tell the board that the references to the Antigua Labour Code should be to the Antigua and Barbuda Labour Code.
I think that'll have put us off our stride enormously.
Well, I wouldn't want a judgment to
No.
include the wrong citation to the Act.
Quite right, too.
If it should be wanted, there is a complete copy of the code available, which I've handed up if it should be needed at some
It
stage.
may be useful for whoever is preparing
Yes.
the board's reasons to have the full document.
Yeah.
But I noticed that the index to the authorities has got the full title, so
I'm glad
the
about
odds are
that.
we might have got it right, but thank you.
I'm glad about that. My lady, my lords, you will have appreciated from what you have seen that our principal submission is that there was no justification for the course which was taken by the Court of Appeal. The industrial court gave satisfactory consideration and satisfactorily disposed of the issues. And indeed, its principal findings were upheld by the Court of Appeal, which in our submission then proceeded to put an unwarranted gloss on events, which with the greatest respect it should not have done. Can I just give you the principal dates? The appellant worked for the respondent under the terms of a contract dated the 1st of June 2001, until his employment was terminated by letter dated the 29th of August 2001, which are probably the only two contemporaneous documents which need trouble you during the course of the hearing, and perhaps I could take you to them straight away. They're at pages 111 and 112 of the record. You will see at 111 the agreement, and the parties at the top, the agreement to employ Mr. Jarvis for a period of 1 year from February the 19th, 2001. There are then the provisions as to his salary, provisions for the benefits which are required by the law of Antigua, and his description in the fourth short paragraph as a full-time pharmacist, and various rather general obligations after that. Both the parties signed 1st of June 2001, and it appears never to have been disputed that, in fact, Mr. Jarvis, at the same time as undertaking this employment, had another job. He, in fact, works as a customs officer at the airport in Antigua, and indeed, on 2 occasions, has stopped me in the queue as I've been going into that island to do work in order to discuss the progress of this appeal.
He's a customs officer or an immigration officer?
Well, he is the gentleman in the box who looks at your passport. I don't think I think it's one department effectively, but he was at the time working at the seaport. But he's now to be found, one of the gentlemen in the glass boxes. As I say. Well, he has so far. It remains to be seen whether I dare go back. But my lord, that is, it's never been a dispute that his work was always organised in shifts, whether it was full-time or whatever those words.
His day job, but this was a full-time evening job.
Yes, well, he appears to have worked. There is a reference to shifts at some point in the record, but it doesn't appear to be important. But he worked in the evenings, and obviously his hours changed, and indeed the shifts were the bone of contention which brought matters to a head in August, and eventually led to the second of the documents which your lordships have in the record at page 112, which is dated the 29th of August 2001, addressed to Mr. Jarvis and signed by Ms. Romanito Francis, saying, further to our communication at the meeting on Tuesday the 28th, now that's the day before.
I think we've read it.
Yes, well,
my lady, please do stop it. We probably read everything because there was so little to read.
Well, indeed, my lady, I'm not proposing to embark on a long campaign myself, because I know that your ladyship, you will have appreciated what the issues are. The circumstances, we say, were conveniently set out and dealt with in the judgment of the majority of the industrial court, which is perhaps easiest to look straight at page 37 of the record, where the majority judgment begins. And we see that recognises, to begin with, the fact of his simultaneous working as an immigration officer. And then the contract is set out at page 38. And then the first paragraph on page 39 really tells the story. I don't know whether your ladyship would like me to read that or just indicate that that's where it's set out. Yeah. The letter I've shown you has just been, is then set out in full, and the parties' arguments appear on page 40. Mr. Archibald, appearing for the employer, made the submission that what had happened was a repudiation of the contract of employment by Mr. Jarvis, and also that his statement that he couldn't meet the new schedule showed an anticipatory breach of contract, and then the argument against him from Mr. Christian saying the opposite, that there was no anticipatory breach of contract and no intention shown by the employee of not resuming his duties. The Industrial Court sets out the questions which it considered had to be asked and answered in the middle of page 41, and then we have the decision on page 41 and page 42. Again, if it would assist, I can read out what they said, but I'm obviously anxious not to do anything which is gratuitous. It is very short. The probation point appears to have been a complete red herring because, unfortunately for Miss Francis, she was wrongly advised about that. It didn't apply. But that was the basis upon which she terminated the employment. And as the Industrial Court found, there wasn't a repudiatory breach of contract, there wasn't an anticipatory breach of contract, which really left nothing. And the provisions of the Antigua Labour Code being what they are, it followed as night followed day that there was an unfair dismissal. And really that is what we say. The correct analysis of the case and the events leads inexorably to.
You say the original contract had not been brought to an end.
Yes.
Other than by the letter.
Yes.
And so the Court of Appeal going off into some uncertainty about a new contract was a complete misconception because the old one hadn't.
Exactly that.
And what do you say about the position of an employer who wants to change the hours of work of an employee? What's the position about that? Well,
I mean, there could well be, in different circumstances, an argument about it. There could be plainly a full-time contract would demand a certain amount of work, and on different facts. It might, if an unreasonable and intransigent reaction was met with from the employee, lead to a satisfactory finding or satisfactory reason to terminate his employment. But here we not only have Section 59 of the Act, but also Section 58, which requires the employer to act reasonably. And this whole issue appears to have blown up on the 28th of August. And it was all over by the 29th. We say that there was really no attempt to establish a reasonable approach by the employer, indeed in the courts below. The Court of Appeal agreed with the Industrial Court as to the no repudiatory breach, no anticipatory breach points. And we say it was an unwarranted gloss on facts to go off onto the question of uncertainty. And it hadn't been raised in the Notice of Appeal. I don't know if your Lordships have picked that up from the Notice of Appeal itself. It's at page 56 of the record, where the...
But they did allow both parties to make submissions on it.
Yes, although there seems to have been some sort of argument, some sort of cross-purposes situation, because at one point they record Mr. Jarvis's counsel as having accepted uncertainty, but it rather looks at that passage of the judgment as though what he was doing was insisting that he was pointing to the features which made the original contract certain, and then either going along with what was put to him by the Court of Appeal or it isn't really very clear what we don't have the written submissions, unfortunately, which were before the Court of Appeal.
Mr. Guthrie, speaking myself, it seemed to me that the central sentence in the decision of the majority in the Industrial Court is halfway down page 42, just at the end of the second larger paragraph. The working hours of the employee were unilaterally changed contrary to the contract of employment. Now, leaving aside the muddle about trying to terminate it and summary dismissal, probation and all that, as I read that, the majority is saying that it was in fact a term of the contract at the very least, that the hours of employment would not be changed without consultation and an attempt to negotiate or something of that sort.
Yes, certainly. One might also say that that is predominantly a question of fact rather than a question of law, and they having reached that conclusion.
Yes, I mean, we haven't unfortunately got very much evidence to back it all up. But I mean, it's certainly a possible interpretation of the notes of evidence.
Yeah.
But it doesn't seem to have been explored at any great length, at least as far as one can tell.
Well, it doesn't seem from the notes of evidence that anyone was arguing that that there had been this creation of a new vague contract.
Yes, I wasn't so much thinking of the new contract as looking at the old one and seeing what was the impact of the old contract on a possible change in hours of work. What were the limitations on that? Because that seems to me to be fairly central.
Yeah. Well, it was found in the employee's favour by the industrial court and was well within the scope of their inquiry, so to speak.
Yes,
that's right. You don't say that the contract was that it was a full-time contract of employment, but that he could indefinitely, or at least without limit, have a day job with the immigration authorities. Yeah. All that's said is that unless and until that was changed by reasonable notice. Is that how you...
Well, yes, that, and also it was plain, and I think never in dispute, that it was always known to the pharmacy that he worked for the immigration people. That, in fact, had been the position before he entered into the written contract.
What's the effect of that? It's not that it makes him entitled forever to... No.
Well, he has to fit in with it. I mean, he has to be able to perform a full-time work for the pharmacy. And if he can't do that, then he would be in breach of that contract.
Yes, but if they had said, this isn't working out, within 2 months you must make arrangements so that you can work during the day, would that have been breached by the employer?
Probably not.
No.
Probably not. But again, one is dealing with a hypothetical situation and not the situation which actually developed.
Can I just ask one further thing, Mr. Guthrie? I think you mentioned it earlier, but I'm not sure that I caught it. The hours of work as a customs official, immigration officer, were they liable to change, or were they always...
I believe that they could change, and it does appear, and well, I've understood the position, that it was a fairly loose arrangement. He began not working on a full-time basis, and he was asked to work on a full-time basis, and he said, well, yes.
Yes, but, yeah.
It was only when Miss Samuel came back and from her course in Jamaica and insisted on a schedule which didn't, in fact, fit in, that matters came to a head, and they came to a head very quickly, and he wasn't really given an opportunity to do anything about it.
No, indeed.
The first bit of bold on page 42, that's not quite right as a matter of law, is it? It may be right in this case, but...
No, it's not quite right in the sense that there is a specific provision in the Labour Code, which may be what your Lordship is thinking of, under C59, which deals with the facts as...
Yes. Well, they're talking about... Are they talking about... Well, yes. They're previously talking about common law, aren't they?
Yes. Well, I read that as being a kind of general remark. I'm not quite sure why it is in bold, actually. I think that may be something to do with the printing rather than the emphasis.
Yes.
But I think what they're saying is that the employers, having nailed their colours to the mast, they can't suddenly change tack. Yes. Whereas if that is taken as literally true to every situation, it is wrong. Yes. And indeed, it's even wrong under the Antigua Labour Code, because Section C59 does deal with that, or Section 58.2, I'm sorry, because it deals with what happens if you dismiss for one reason, and in fact you're mistaken about that. You can still rely on the true facts if they would have justified it. So, but no, if it was taken as a bald statement of applicability in all circumstances, it wouldn't be right.
Well, actually, 2 is getting at a difference between Antigua law and English law, isn't it? 58.2.
Yes. I have checked.
The facts have got to be, the employer's got to get the facts right.
Yes.
Yes.
I think that's the main thrust of what 58.2 is about. Although I can see that it could also apply where the employer thinks one thing and then it turns out there's another thing and the other thing is also good enough.
Well, I mean, this is what this appeal is about, but the last sentence of 58.2, the test shall be whether the actual circumstances which existed, if known to the employer, would have reasonably led to the employee's dismissal.
That's right.
Yeah.
So it's getting at what the actual circumstances are rather than what the employer reasonably thought they were, which, as I say, is a difference.
There's a difference between.
But C59 is completely clear about what you're supposed to do.
Yes.
If you're not instantly entitled to terminate employment. I don't think 59, nobody suggested that 59.1 applies, and after that you've got to start giving people warnings.
Yes.
And I think in a sense this comment about nailing colours to mast is aimed at that. You've got to say what it is you don't like about what somebody's doing.
Well, I might also say that the Court of Appeal's findings are somewhat internally inconsistent, because they both seem to say that the first contract wasn't put to an end, and then that it was.
Well, they say they put it both ways, don't they?
Yes, but
they could only have found they could only have considered the question whether a new agreement was uncertain or not on the premise that the old one had gone.
Yeah. And that, in the scenarios they were considering, would appear to have been something which would have to have been mutually understood.
Yes.
Which it plainly wasn't, because he turned up to work and she wrote the letter she did. I mean, because she wouldn't have had to
there's some issue as to whether he turned up for work on the next day or the day after. But certainly the employer wrote the letter based upon the original agreement.
The fact that he plainly considered he was entitled to turn up for work.
Yeah.
Well, I made the remark about the Court of Appeal because paragraph 28 is having it both ways.
Yes, that's what we say.
Yes.
Yes.
If they intended to vary the original contract.
Yes.
If they intended to bring it to an end.
Well, my lady, I really don't know whether there's anything much I can do by way of further assistance.
Well, you've been very helpful so far, Mr. Guthrie. Let us see whether anybody else would like further assistance from you. Is there anything more you...
I don't think so, Brendan, no.
We'll just rise for a moment.
What rise?
Well, the board is very grateful to you, Mr. Guthrie, for the further light which you have shed in this troubling little case. And the board will humbly advise Her Majesty that the appeal ought to be allowed. They will give their reasons later.
Should I say anything about costs?
What would you like to say about costs?
Well, we would ask for an order. I think I should indicate that it may well not lead to anything, because there are now great difficulties, obviously, in enforcing an order against someone who I don't think has any lawyers, and the rules here now provide for quite substantial deposits to be placed before an order for taxation is ever given. So, but I would ask for an order.
Is it still in business?
Yes, the shop is farm. I believe it is. I should also draw your attention to the fact that both that under the Antigua Labour Code, in ordinary circumstances, the industrial court does not itself make orders for costs, and the Court of Appeal didn't make an order for costs. But of course, we have had to come here.
You have had
Yes.
to come here.
Yes.
Well, we will think about it, but
Well,
you'll get the reasons, and that will include what we say about costs. Is that,
right.
is
Yes,
that the sensible
yes, no,
way?
I've said all that I want to say.
Yes. Thank you very much indeed, Mr. Guthrie. I was going to ask you about that.
I'm sure you'll get let in next time.
Oh, we'd be worried if you didn't.